Well, this morning, the Murugappan family has been given some reprieve. They'll move from immigration detention on Christmas Island and be reunited in Perth. But it's not the happy ending to a fairy tale that many hoped, and it was never going to be that way. Refugee Legal Executive Director David Manne joins me live now. David, you've seen so many of these cases over the years. This is a story that has never, I guess, been kept quiet because of the activists in the Biloela community wanting the family to stay. Now, they're not on Christmas Island, but they're not back in Biloela either.
No, that's right. It's been a very prominent case. I think the main reason, Laura, that it's been such a prominent case is because it's about a family who've been embraced by the Biloela community, and it's about questions of fundamental decency and humanity, really. I think in relation to the announcement today about the direction that this case is turning in for the family, I think the first thing is that it's certainly a relief that the family are to be reunited. I think that is both a question of common sense and compassion, but reuniting families is critical as a matter of basic decency, but it's also a fundamental right. So I think that's a relief. I think the other thing is that clearly the decision is to bring the family to reunite on the mainland and to have Tarnika next to a hospital where she can get critical medical care, which is clearly going to be needed on an ongoing basis, given how acute her condition appears to have been. So that's certainly, a relief. But there are big questions that remain.
And what are those questions? Because isn't it correct that under the law, the family isn't afforded protection?
That's right. At the moment, as it stands, the family have been rejected in relation to their refugee claim, although there is still an outstanding case to be heard, and that's the case of Tarnika. And that is a matter that still is to be determined in relation to her protection needs. So there are still outstanding legal matters. It's not over on the legal front by any means. But I think the real question here is about the family's sort of enduring future. What this decision today does, it does nothing to resolve their future. And what's needed here is an enduring solution which grants the family permanent stay in this country so that they can return to the Biloela community and know what the future holds. And I think that's where home is for them now. And this decision doesn't do that.
But David, why this family? They can't be the only one in this circumstance, but the Biloela family, and this family of four in particular, has really divided Australia, you've got to say. They've lost many legal challenges. Why should the minister grant this family an exemption? Well,
under Australian law, even if someone doesn't meet the technical legal tests to be found to be a refugee, for a very long time, for many, many years, there has been a power under the Migration Act for the Minister of the day to substitute that decision in the public interest and to do so on humanitarian grounds where there are compelling grounds to intervene and allow someone to stay, or in this case, a family. So there's nothing unusual about this. That power has been used countless times by both sides of politics across the political divide. It's used every year in many cases by the minister. And it's in recognition that although someone doesn't meet the technical legal test, there are often other considerations which go to questions of basic humanity, basic decency and fairness. And that's why.
Indeed. And your arguments are valid, and I think speak to so many people, but the government's border protection policies, whether you agree with them or not, they have stopped the boats. Many are concerned that stop the boats arriving to Australia, I should clarify. Doesn't mean there's not refugees and asylum seekers right around the world looking for protection, but what does this decision do? If an exemption is given in this case, do you accept that there might be some kind of precedent?
Well, the first thing is that the precedent's already been set to intervene on humanitarian grounds. That's happened over the years so many times by ministers, both coalition ministers, Labor ministers. So the precedent's already been set to do so. I actually think, Laura, with this case, that the question is not whether the minister should intervene, whether the government should intervene, but why not? But just on the question of border protection, there is simply no evidence to suggest that acting compassionately in the public interest here would somehow see the resumption of boats. And I think that, the kind of calculated cruelty that has been inflicted on Tārnika and her family, to somehow claim that this is about saving lives at sea is to miss the point that this policy is also destroying lives on land. And it's no answer in this context to claim that that ongoing cruelty, ongoing cruelty toward this family is necessary to stop the boats. Can I add one other point on this, which I think is really critical? Not only have we seen this government and other governments intervene countless times using this special power on humanitarian grounds without the resumption of boats, but we've also seen over 1,000 people brought back from Manne and Nauru, well over 1,000 people. There hasn't been a resumption of boats. We've also seen, many people, hundreds and hundreds of people resettled to the US under the special deal with Australia, resettled from Nauru and from PNG. We haven't seen a resumption of boats. We've also seen people resettled from Nauru and PNG to Canada or to Europe. We haven't seen a resumption of boats. So I think that really that argument is not only baseless, it's want of evidence. And I think that there always needs to be room to act compassionately. And here is, if there was ever a case where that power should be used, it's here.